All right. So welcome everyone. My name is Riley and I am the digital and social media content analyst here at GBBC. And it is my pleasure to introduce the second edition of Hot Topics in Blockchain Law, a virtual roundtable presented by the GBBC initiative, the International Journal of Blockchain Law, also known as IJBL. And the IJBL is an open access online journal written and edited by lawyers and designed to help business and non-legal communities better understand the world of blockchain and digital assets. So if you want to check out the IJBL, we will be sharing a link in the chat shortly. And please feel free to submit any questions you have throughout the session into the Q&A box below. Now I will turn it over to GBBC Chief Legal Officer and Head of Policy Americas, Andrea Tinianow, to introduce the speakers for today's session.
Riley, thank you so much, and welcome everyone to this edition of Hot Topics in Blockchain Law. There is a lot going on in the world today, in the world of blockchain, and especially legal issues. So I think this will be an active conversation. I understand that you have the ability to send us questions and topics, so please feel free to do that. And if we can address your questions, we will absolutely do that. Before I get started, just a couple of some housekeeping items. I want to make sure that everyone understands that we are aiming to have a really robust conversation here, and the views presented by our esteemed lawyers, they may not necessarily be holding those ideas as their personal ideas. They may be making points so that we have a fully thoughtful conversation. So I just want to make sure that everybody understands that. Like I said, I want to thank GBBC very much for hosting this conversation. And now what I would love to do is have our team, our panelists of lawyers, to please introduce themselves, starting with Eric.
I'm Eric Hess, Hess Legal Counsel and host of The Encrypted Economy.
David.
I'm Dave Adlerstein. I'm a corporate lawyer at Wachtell, Lipton, Rosen, and Katz in New York, and I'm a member of my firm's crypto team.
Jason.
Jason Gottlieb from Morrison, Cohen, LLP in New York, and I run our digital assets group as well as our regulatory enforcement group.
Laura.
I'm Laura Douglas. I'm a senior associate in the financial regulation team at Clifford in London, and one of my main areas of focus is UK crypto regulation.
And Sarah.
I'm Sarah Brennan. I'm the general counsel of Delphi Ventures and Delphi Research.
And of course, last but not least, Stephen.
Steve Palley. I am a partner at Rudnick, based in Washington, D.C., and I co-chair the firm's digital commerce practice.
Okay, thanks so much. We were just earlier discussing how to even begin to focus on the myriad topics. And what we'd like to do is start by looking at the recent SEC rulings, enforcements, and statements. And we're going to kick off with Eric here to discuss and provide a little background on the proposed rule, the proposed safeguarding rule for registered investment advisors that the SEC issued last week, I believe. It feels like it was weeks and weeks ago because it's such a focus for all of us, but it was last week. So Eric, if you could kick off, please.
Sure. The current state of the custody rule is, goes back a number of years, back to Dodd-Frank, and Congress basically gave the power to the SEC to regulate the custody of funds and securities held by investment advisors. But they debated limiting the authority to that, but they actually chose to provide for greater authority. So in many ways, this expansion is well within the authority specifically delegated to the SEC by Congress. Also important to remember that this is regulating an intermediary, except of course, where they're not, which we'll get to. And it'd be another thing if you were trying to mandate the trading of digital assets, keeping it to digital assets on this point through RIAs. But it's important to also remember that this is going to be more mainstream or institutional adoption channel, not your cypherpunks or degens. So to focus on the positive and gradually get to some of the things that concern me more, obviously not a fan of the securities discussion in the proposed rule, but I think that's more noise, I hope.
Eric, I'm going to just jump in for a quick second, because when we say, so there's an assumption basically is what you're saying in the rule that tokens are securities. That's sort of
it's more just like a throw-in statement. It doesn't necessarily, find itself into the rule itself.
Right.
And so in that regard, it's just sort of maybe to digital asset advocates more annoying than substantive. But what I do like about the proposal, there's a lot of things I like, a lot of things I don't like. It recognizes digital assets as an asset class that could be held and possessed by an RIA, which is actually, the fact that we're having that discussion is actually good. I mean, in a different environment, if there was more trust and less hostility, this would be an open conversation that I think a lot in the industry would welcome, particularly since it also starts to touch on the customer protection rule and good control location, which would not apply to RIAs, but would impact the way that brokers might be able to hold digital assets. So there's a lot of good that could come out of it. Unfortunately, there's really not enough clarity around how a qualified custodian would hold or possess a crypto asset. So they kind of punted on that. With that said, they have the authority to do this under the rule, but do we really want to have more enforcement actions to kind of get clues as to what this means? Obviously, I don't think anybody here thinks that would be a positive outcome. The harmonization of the framework across asset makes sense for RIAs, but it also imputes additional liabilities on certain assets, and even certain kinds of defined discretionary authority that didn't previously exist. And you have to almost scratch your head, discretionary trading authority, how that actually links in with custody. Maybe there's a case that in certain cases it does, but even with certain exceptions built in for that authority, sorry for the technical, it still kind of makes one, wonder whether more discussion should be had on this for sure.
I'm just going to jump in for a quick second, because it sounds like and based on my read as well, there are more requirements. They're exercising their authority granted to them, yes, but it imposes a whole lot of rules and a whole lot of additional. And again, we're talking about RIAs, or registered investment advisors. So these are being imposed on registered investment advisors, used primarily. This isn't your mom and pop like retail, but it makes for a more restrictive, and what you were saying is there are rules, but like how to comply with these rules, because there's so much to it. And I'm wondering, David, if you could comment on that and just offer a bit more on what the implications may be of more restrictive requirements and expanding the assets and the expanded rules pertaining to crypto assets.
Well, a couple quick points, and I think then Sarah is going to have some things to jump in with as well. One is, it's a pretty short comment period for this rule. The custody of crypto assets is complex, and there are a lot of things to chew on for the industry. And for something that has repercussions that are this broad ranging, it's going to be difficult to cram a really lot of good, thoughtful work into the time period between the rules proposal and its proposed effectiveness. The main thing I would say is Chair Gensler recently made a public statement to the effect that many crypto-centered institutions who purport to be qualified custodians may not actually be qualified. And I do want to point out that I think it's very, very idiosyncratic to custody crypto assets relative to traditional securities through the very familiar framework with DTC that we've had in place since like the 1960s. The idea of being able to hold crypto safely and securely in cold storage is something that the industry is uniquely set up to do, and people understand how to operate with multi-sig arrangements and different kinds of best practices, because this is something where, like, if you're Coinbase, you're under assault 24/7 from people who would like to get your private keys. And there actually are very sophisticated protocols that have emerged within the industry, uniquely designed to safeguarding crypto assets. I don't think the traditional custodians have that. Traditional custodians would probably have to look to the industry for sub-custody. And so if you're going to create a
or buying certain solutions, right?
Exactly. So if you can't look to the kind of traditional custodian industry and you can't look to the crypto industry, where do you look? And the answer might be you can't look anywhere, which I think would be an unfortunate result. That I'll turn it to Sarah.
Yeah, I was going to pick up on those points. So like as it stands, a lot of VCs self-custody because there aren't solutions in the marketplace, especially so VCs are investing in projects that don't yet have a token, right? So by the time that you know your tokens like unlock, there may not be a solution in the marketplace, and this would just like narrow down the class of solutions that are available to you. And there's a note in the proposal that says we already think that these self-custody like arrangements are not legal. So it's just like, to me, it's a denial of service. And the other point I'd like to quickly make is for VCs in crypto, you become an RIA at 150 mil under management because you're not eligible for the VC exemption, which is like particularly low because crypto vals, if you're close to
Valuations. Crypto
yes, crypto valuations when you're a VC, right, around projects have been very high before they even, you know, the token even exists or comes to market. So you're looking at registering, you know, and, you know, you could have like 500 million under asset 1 month and 100 million the next month. So you're looking at that level of volatility and, you know, kind of aspirational valuations when you're seeing what you have under management as well. So I think it's a pretty harsh combination of results there.
Yeah, and just to kind of jump in, because I know we got a lot to cover, but some of the provisions regarding indemnification, the SEC mandates that the investment advisor have a contract with the custodian directly and mandates indemnification from the custodian for simple negligence, which is a bit mind-blowing, the intrusiveness on that contractual relationship. And even more so, the custodian has to consent to enforcement of the judgment by either the RIA or the SEC. And by the way, this also applies to foreign financial institutions. There's a lot here that we could spend a whole hour, 2 hours on this, right? But we're not. But I just want to leave on this point. Once we start getting into foreign financial institutions, we're talking about foreign policies. If you're effectively banning foreign custodians from servicing RIAs, unless they consent to this and SEC enforcement, that is a foreign policy issue. And how could we even complain in the US if similar laws also prohibit our businesses from participating in foreign markets under a similar justification? So that's probably one of the hottest points to me. It's mind-blowing, the extension into the foreign policy space on this. This is comment period. I can't imagine that this is something we actually want. And I'm hoping, as hot as this is, there's other points that are going to be subject to more discussion.
Well, I'm going to get to Stephen, but I want to mention 2 things that GBBC is actually preparing a response. So that is such a great point. And I know that's something that we will likely include in our response. Yeah, fantastic point. Stephen, please jump right in. I know you had some practical points you wanted to share.
I mean, with respect to what my colleagues have already stated, I don't really have anything. It may be a surprise, but I don't actually have anything brilliant to add. I think they cover the waterfront.
Oh, okay. I thought there was something there. Okay. Oh, maybe it was Sarah. Did you have something else that you wanted to add?
Oh, no, that was the point.
Okay, great. Let's move on to if I don't know if anyone from the group had anything else they wanted on this particular subject. We'll move on to the Kraken settlement, and that was a settlement with the SEC on the topic of staking as a service. Sarah, I know that you had some points you wanted to make on that.
Sure. So I just think it's kind of a sub point, and I'll let other people kind of go into the fact pattern a little bit more. But I think when we look at SEC enforcements in this industry, the hope is always that there are elements of that service that distinguish it as worthy of enforcement, while like other similar services are not. And this was the first of its kind, and the SEC's remedy was basically to fine Kraken, have them shut down the service permanently, and promise never to do it again. And so, you know, if there are problematic elements and this is like their first go at it, you would think that you could fine tune things and have a discussion of what's problematic so that you could continue on providing the service. But I think the complete shutdown is pretty ominous to anyone or should be to anyone who is engaging in a similar type of service provision.
Yeah, I mean, I would add to that, as a practical matter, it's difficult to know what to tell clients, particularly ones who are operating centralized platforms, when people call and ask about staking or liquid staking. I mean, I don't see, there's not a lot of nuance, and there's not a lot of fancy dancing you can do, I think, to avoid the to avoid enforcement. I mean, I guess the question is, will we see that spill over into truly decentralized, which is a phrase that carries a lot of weight, but truly decentralized platforms?
If such exists, and then you could have the same, you know, you could have the same result where Dow gets sued by a regulatory agency. So
and I think we know that the SEC is looking at staking services provided by or through decentralized platforms as well. I don't think there's been any open enforcement activity at this point. I don't recall seeing anything in the news.
No, I'm just thinking back. Yeah, David.
And Andrea, because we probably have people participating in this webinar with varying degrees of background knowledge, maybe just a quick word about staking. So there are crypto protocols, not Bitcoin, but Ethereum would be a prominent example, where if you participate as a validator in the network, you're able to get a return basically on the crypto asset that you have staked within the protocol to serve as a validator. So to do that within the Ethereum network, you have to have like 32 ETH, and you get something like 3 or 4% yield paid in ETH. So there's an incentive to do that. 32 ETH, even after the crypto market crash, is still worth a lot of money. Your average retail investor is not going to have $50,000 worth of Ethereum, but there's an ability to get this kind of return. So it's an attractive prospect to be able to pool your assets with other folks and be able to have a service provider do this for you. So the denial of the ability to do that at all for Kraken is going to leave those customers high and dry. They're either going to have to find another centralized provider who can do that, who will have to try to distinguish the features of their program from Kraken's, or they'll have to go into the world of like decentralized finance and try to do it on their own. And there are pros and cons there, because Kraken, whatever the SEC may want to say about it, is a supervised entity. They make efforts to comply with the law. And if you drive people sort of out of the light of day into these dark corners, you're maybe creating other problems, including in areas like KYC, AML. And I think that's a theme that'll come up when we talk about some of the banking industry issues that we're now seeing as well.
Yeah.
Here's the problem I have with it.
Tell us.
So in a statement accompanying the settlement, Chair Gensler comes out and says that the Kraken settlement should make clear to the marketplace that staking as a service providers must register and provide full, fair, and truthful disclosure and investor protection. Nobody here on this call is going to argue that people should provide full, fair, truthful disclosure and investor protection. Like, everyone likes that. That's good. That's sort of like saying, you know, ice cream and rainbows are good. Fine. Everyone likes it and everyone's going to say that. But he sort of like hides that must register and do those things. And the question is, register as what? After the settlement, Gary Gensler goes on MSNBC and says, well, Kraken knew how to register if they wanted. It's just a form on their on the website. And yes, the S1 is a form that is accessible on the SEC's website. You can download it if you want, but it needs to be approved by the SEC. You have to fill it out and have them approve it. And there isn't a section in it for, you know, staking as a service. You're already in, when they ask if you want to register, you're already in the other box. So you're already trying to explain it. This attitude that the SEC has had, that everyone's a scofflaw and everyone could come in and register and they're just choosing not to, it smacks, it's frankly a little bit insulting, because it suggests that, you know, all the people on this call and all the other super sophisticated lawyers in the space aren't trying to register, haven't told their clients, let's try to register, or have tried to work with people at the SEC to do it. It's no coincidence that there are no registered staking as a service providers. Like, that's not because everyone out there is a scofflaw, people like Kraken who are regulated and have been regulated. It's that it's literally impossible to do.
Jason, I'm sorry, Jason, I'm going to jump in. Really great point. And I've heard that. No, it's just perfect. And, you know, we're so lucky to have Laura Douglas with us. I'd really love to get her take from the other side of the pond. Like, what do people in the UK think about all this? And what do you?
Yeah, I mean, actually, I was reflecting, it's interesting because I'm not a litigator, whereas I think a lot of you guys are, but I think maybe, you know, there's kind of a slightly different approach in the UK in that, yes, the regulator, so the FCA, has been tough on crypto service providers, but we've kind of seen that play out through an AML registration regime, which kind of, you know, there's been a whole process around. So maybe just picking up on that point, well, you know, how do you register? In the UK, we've had like a clear, you must register statement. I mean, it's been in the money laundering regulations, and then people had to register. I mean, the downside is the FCA published stats just in January, actually, to say they've only approved 15% of firms who applied to register. The remaining set of firms have either been rejected or had to withdraw their applications. And a lot of those were existing firms. So they've had to stop business, move to a different jurisdiction. You know, that's not a great situation either. Although, you know, I think the challenge has been the FCA has applied a really high bar for the engagement expected from firms. I think maybe some firms kind of that took them by surprise.
Can I just ask you a quick question? When you're saying firms, are you talking about trading platforms, or are you talking about staking?
Yeah.
You're talking about.
Thanks. Good question. So the types of firms that had to register are crypto exchange providers. That's a regulated term. That means like exchanges, yes, but also anyone that is helping, it's like brokers helping you buy and sell crypto. So firms that do that, and also what they call crypto custodian wallet providers or wallet providers. So custodians, but also, you know, that's quite broad. It's not people doing sort of true custody, you know, safekeeping of keys. So they had to register. People thought it was like a notification. Actually, it was a really high bar. We are going to get a proper licensing regime, but that's not here yet.
Thank you so much, Laura. Does anybody have any? I wanted to move on to another topic, but if anyone had any closing out comments that they wanted to make here, I want to just give the group a chance to, if anyone had something they were burning to say. Okay. I wanted to move to a SEC enforcement action, which is the Wahi case, the SEC against Wahi. And Jason, could you just bring us up to speed? I know that there are some things you can and cannot talk about, so we just appreciate your insights.
Sure. Well, happy to talk about this one. And as a disclosure, I helped the Blockchain Association file an amicus brief in this case. So in the Wahi case, the SEC charged Ishan Wahi, his brother and a friend, with insider trading in 9 specific tokens that were traded on Coinbase. That they took information, allegedly, they took information that was that the coins were about to be traded on Coinbase, which they thought would have a pump effect on their price, and they went out and bought some of the token. It was listed, price went up, they sold it, made a profit. That's the general state of allegations, and there have been some guilty pleas on the criminal side. The SEC case in this instance is interesting because for the criminal authorities, for the DOJ to have authority, all they have to say is that this was wire fraud, and that's what they did. The SEC has to say that it was fraud under 10b-5 in connection with the purchase or sale of securities. It has to be securities. So the SEC's complaint goes out of its way to talk about how these 9 tokens are allegedly all securities. Now, of course, the 9 tokens are not defendants in the case. The fact that they were securities being traded on Coinbase would sort of, by necessary implication, mean that Coinbase was allowing the trading of securities, which would have implications for Coinbase. Coinbase is not in the case.
No,
So the
because
SEC
when you say implications, it would mean they're violating federal law. I mean, clearly, right?
it would arguably it would mean that they're acting as a securities exchange without registration, because Coinbase takes a position it is not a securities exchange. It does not allow securities to trade on its platform.
Right.
So by attacking all of these parties and labeling them as securities, when the parties aren't in the room and have no practical ability to defend themselves, the SEC is inflicting damage on those products, which are, you know, a disparate array of products, without them having the ability to practically defend themselves in any way. They can't intervene in the case. They can't sue the SEC. It's just, you can't do that under the law. So as a result, you know, the Blockchain Association brief points out that this is incredibly unfair, and it actually sets new rules. It's beyond enforcement. They're setting new rules, and that kind of rulemaking without the notice and comment that we're seeing in the custody rule section is a violation of the Administrative Procedure Act. We may not like the custody rule that's being proposed, but they are going through a notice and comment period. In Wahi, they're just labeling people securities and walking on in a case that they don't think is going to be defended.
Thanks so much for that that introduction. I'd like to see if anyone in the group has any thoughts that they'd like to share on this, because I think there's some things to unpack.
Yeah, it's interesting. We I worked on the one of the amicus briefs in the Uki Dow case, and we made a similar argument about the CFTC trying to evade the requirements of the Administrative Procedure Act. And for folks who are in the US, if you are an agency and you want to create a rule, you have to follow a procedure for doing so and give people the opportunity to respond. I'll be interested to see if that gets any traction. But
So,
it's
Stephen,
nice. Yeah.
Can you talk a little bit more about that? Because this notion that the are exceeding their authority, I mean, that's really what's happening. And we saw that in the US Supreme Court kind of this week in the case involving student loans. This notion that you've got agencies who are sort of getting out beyond their skis, making arguments where they, you know, regulate, they don't have the strict authority to do so, right? I mean, that's what we're talking about.
So we've had sort of a regulatory state has bloomed in octopusine fashion in the United States over the last 50 years. And we now have a Supreme Court that's fairly conservative. There's this notion, there's this thing in the United States called Chevron deference, which is a reference to Supreme Court case involving the deference that courts are supposed to provide to give to agencies in their interpretation of rules. There's sort of an overlap here. I think the argument that both Jason and I and others have made is that what you're actually doing is you are trying to create by you're basically trying to use sort of plenary regulatory authority to create an opinion or precedent that will have the functional effect of being a rule that applies nationally. Now there's I think the SEC would respond by saying, I mean, there's a procedural response, which is, even if the court were to determine those things are securities, it doesn't really matter because it's not final or binding on anybody else because they're not parties to the case, right? It's not res judicata, it's not issue preclusion or claim preclusion, but it's nonetheless, we've seen in other contexts cases where a court has has issued a default judgment, an opinion on a default judgment in a case, and the opinion in that case has been cited and relied upon by other courts. So it's dangerous, I would say, even though in theory, single district court judge's opinion in one case shouldn't necessarily have an impact on others. As a practical matter, it can, because people will follow the reasoning.
David, you want to say something?
Yeah, I had one quick observation on the Wahi case, which is, and I agree with Stephen's points. I think that if you go back and look at the original complaint, it said that the defendants in the case traded in something like 25 crypto assets, right? And lately, we've heard statements coming out of the SEC to the effect that at the senior most level, there's a belief that everything except Bitcoin is a security. One thing that kind of perplexes me is, well, if everything is security and there was front running in like 25 crypto assets, why were these 9 in particular
Only 9.
selected? And it
Only
just doesn't
9.
create a lot of predictability for the market. The SEC, at least formally, has still not repudiated its guidance for what constitutes an investment contract, which has a test for if an asset is sufficiently decentralized and there's not an active participant sort of pulling the puppet strings, then a token project may not constitute a security. So I think that there really is a lack of clarity coming out of Wachtell, and the analysis that was included in the complaint was rather cursory. So apart from being something where the parties in interest are not participating, it's really difficult to sink your teeth into like a paragraph and a half analysis that is extremely fact dependent.
Yeah. Did anyone else want to make a comment there?
My theory on why they detail the 9 and not the 25 has nothing to do with the comment that they're trying to make about the other 16 not being securities. I think they just ran out of time. Like the DOJ wanted to bring an indictment and they said, guys, we're going to do it on this date. And the SEC said, all right, we're just going to pull from public sources what we can about an array of different tokens. We got 9. All right, that's good enough. Let's go with that.
Yeah, thanks. I'd like to jump back to Eric's earlier comments now. And when he was sharing with us explaining the SEC proposed rule, and some folks, and I think people recognize that the rule has some even greater restrictions or impact because of what's being called the choke point 2.0. Statements out of the OCC and the other regulators pulling back on the bank's abilities to deal in crypto. And I don't know if Eric, if you wanted to comment on that, that along with perhaps SAB 121, which is another very important factor, which again plays into sort of this notion that the rule is out there and it's, on its face, maybe it makes a lot of sense, but when you add in these other sort of important factors, whether it's the banking the statements from the banking regulators, the SAB rule, which requires that institutions that hold crypto put on their balance sheet a liability of the value of the crypto. Can you just speak to that, please? If you can.
I'll lead the topic off and let others jump in, and we'll have a conversation about it. But we spent a lot of time focusing on Chair Gensler and what he says. He's certainly one of the most overtly political commissioners we've had in my memory. But in truth, what's more impactful in many ways is what is happening with regards to banking relationships. Because if you remove the banking relationships for crypto companies and projects, you're basically starving the ecosystem in this country. And the OCC actually has the ability to more directly influence policy than even the SEC in this regard does. I mean, and we could debate that, but fundamentally, the banking infrastructure is critical. And there is some concern that what's happening with Silvergate is just it's another quote unquote crisis for the OCC and the SEC to not let to go to waste and to amp up the restrictions. Now there have been joint statements by the banking regulators about liquidity in crypto, and I mean you've seen reduction in the balances held by Signature Bank, and certainly Silvergate had a very big impact on banking in the system with their SEN network, SEN. So these are all concerns, because if we need banking for these projects, and without it, the classification, maybe secondary, as important as that is also, but I'll let others comment on it.
Yeah, David, please.
Yeah, one thing I would say, both in defense of the SEC a little bit, just to be contrarian, and also banking regulators, is that the crypto industry, unfortunately, is witnessed by the implosion of FTX, by Celsius, which I think we could acknowledge probably didn't have the the best operation that they were running. It's not a squeaky clean industry, to say the least. There are problems that can be found, and it is completely appropriate for the SEC to crack down on bad actors where they have. And it's also appropriate for financial institutions to engage in heightened due diligence with regard to customers. I think that calling it choke point 2.0, maybe goes a little far. Choke point, the original Operation Choke Point was a DOJ investigation into banks that served a range of sort of like disfavored industries. So, if you were like a ATM provider in small stores, or like a firearms dealer, or ran a pawn shop or something, that covered industries like that, and it really did sort of operate to crack down on money laundering that happened in certain industries, but it was
backdoor. But it was a backdoor way,
right? But it was a backdoor to basically try to starve, these industries a little bit. And I think if you look at the two recent joint bank regulatory statements, they do sort of go out of their way to state, although it seems a little bit perfunctory in context, that financial institutions are not discouraged or prohibited from doing business with any particular category of industry. That being said, though, the universe of financial institutions that will do business at scale with the crypto industry is really vanishingly small. I mean, I think like for an individual consumer, sort of anyone can continue to have like a Coinbase account or whatever and run it through their own personal bank account. We're not talking about that. But if you're like an institutional party and you want to have a banking relationship onshore in the United States, that's a difficult thing to do. And it really creates a double-edged sword, because if you're going to effectively drive the industry away from the regulated U.S. banking perimeter, you're going to drive them into the arms of offshore financial institutions, which in certain cases could be fine, in other cases might not be that fine. And that's where we've run into some issues that you've seen with stable coins like Tether, who had a lot of difficulty in establishing banking relationships that may have helped foster some not ideal activity. Let me turn it over to others, but I think there's a balance to be struck here between, on the one hand, being safe and sound and not allowing these issues to infect traditional banking, which is very important. But on the other hand, not closing the door off to the responsible industry parties that just need to be able to service their customers.
David, I wanted to just add one thing, because, and maybe Laura can comment on this. I was speaking to a registered UK, someone from a registered UK exchange, and they said as a result of the US regulations, or the statements out of the US banking regulators, that the banks in England were taking notice, and banks from other parts of the world were taking notice. And they were also, I think, heightening their sensitivity to working with crypto service providers. So I think it's not just happening. It's, these statements, we think about it here in the US and the impact in the US, but they're far reaching. I don't know, Laura, if you have seen that as well.
Yeah, I mean, I think I'd agree with that, in the sense that, there's no, I guess, equivalent of what we're calling choke point 2.0, in the UK coming from sort of UK authorities. But as a sort of general risk matter, we see institutions, assessing the risk, particularly in light of, recent events over the past few months, whether that's FTX or whatever it might be. I mean, I think the feeling, or the reaction, I think, from the UK regulators, and to some extent the EU ones as well, is I think it's reinforced the need to move quickly to introduce more of a comprehensive regulatory regime for crypto asset firms. So, in the UK, we've got the Markets in Crypto Asset Regulation, which has been agreed. So the text is agreed. It's not yet been formally published. But, that's going to introduce a licensing regime across the EU for, pretty much most crypto asset firms that do business there. And so the being formally regulated, having regulatory capital, liquidity, systems and controls requirements, it is, I think, an important step towards then, financial institutions that are regulated today and need to, worry about this stuff from their risk perspective, their own regulatory and risk obligations. I think that gives them, or should give them, some comfort, because at the moment, kind of maybe in contrast to the US approach, most crypto assets are not considered regulated financial instruments today in the UK or really the EU. And so, actually that activity, other than for AML purposes, is largely, unregulated.
Yeah, that's really that's so helpful to hear sort of the other perspective. Just great. And I just want to thank you so much for joining our team
Pleasure.
here. I'd like to shift gears, not 180 degrees, but maybe 45 degrees or 75 degrees to private action, private litigation. And there are two I'm thinking of that are kind of interesting, but I'd like to focus on a case out of England, and I think it's probably London. We're calling it the tulip trading case, but it has to do with the question of whether a court is willing to hold BTC developers liable, and actually not just liable, but to attribute to them fiduciary duties, fiduciary duties toward BTC holders. And I'm hoping, Laura, since you're on that side of the world, if you could, I'll just mention that we actually, this group here, we were discussing the case, and the US lawyers, I think, had a very a different approach. So we'd love to hear it from the, if you could lay it out. And I think the group will just chime in, because everybody has an opinion here.
Yeah, very, very happy to. So kind of the background to this is that the claimant or plaintiff in this case, so he owns, a lot of Bitcoin, I think something like 4 billion apparently of Bitcoin. And he says that effectively his computer was hacked, his private keys removed, but he knows where the Bitcoin is. He knows it's in two wallet addresses. And so his case, he applied to the English court for an order against around 14 software developers who he claimed could basically change the code to give him to transfer the Bitcoin to a different wallet address he has access to, basically give him his Bitcoin back. And the basis of his argument was that those software developers collectively owed a fiduciary duty to Bitcoin holders, and therefore to the complainant. And so the court could require them to act in accordance with that duty to give him his Bitcoin back. So the first instance case, the judge dismissed the case, basically saying there's, trial. Basically said there was no serious case to be tried. This isn't something that English law would currently recognize as, where a fiduciary duty would arise. It went to appeal. So then the appeal court, and this is, I think, the bit that sort of caused, the kind of interest. The appeal court, basically, they upheld the appeal. They haven't said that there is a fiduciary duty, but what they've said is that there is a realistic case that needs to be considered further. And so basically they've sent the case back to the first instance court and said, no, you've got to try this properly.
Laura, so
yes.
Really, so the court basically said there could be. There could be. There could be fiduciary. And I think they also said something along the lines that we don't, the current state of the law, you can tell me if I'm wrong, but the current state of the law may not impose these types of fiduciary obligations, but we could see it may be that the law should be evolving in an instant where you have a party that can control the assets of another. And in those cases, maybe there should be a type of fiduciary obligation called, an ad hoc fiduciary duty or something along those lines. So that was what I saw from the opinion. But I think also the appellate court discussed was we don't really know the facts. Like the plaintiffs are saying, well, we can identify and the defendants are going, no, it's decentralized. You can't. And I think there's just a question of, is this decentralized or not? Can the people make these changes? Is it, would you agree?
Yeah, I mean, I think that's probably a good summary. So the judge says, they recognize this is the appeal court judge, they recognize that if the case ultimately succeeds, then that would be a significant development to UK common law on fiduciary duties. So yes, it would be like a major development. But basically they said, look, you need to look at this properly on the facts. And really, I think the key fact that needs to be considered, and this is kind of a quote from the judgment. I mean, so the judge says, if the decentralized governance of Bitcoin really is a myth, then in my judgment, there is much to be said for the submission that the Bitcoin developers owe fiduciary duties to the true owners of the property. So basically, that's saying, well, actually, we need to look at whether this is really decentralized or not. And if it's not, and we can identify these developers, there is a good argument to be looked at as to whether or not they should owe, and indeed can be, the court can decide that they owe fiduciary duties. But we're not there yet.
Anyone like to jump in here?
I mean, I guess the question I have, the way I read it as an American lawyer, is that it looked like the court was saying, we're not saying there's a fiduciary duty here. There may not be, but if we take the facts that are proposed to be true, which is what the standard you'd use in the United States, sure, maybe there's a fiduciary obligation. We were talking about this before. I'm kind of reminded of, this is not a negligence case, but I'm reminded of a famous case that every lawyer studies in first year torts in the United States, Paulsgraf versus Long Island Railroad. And the question there was, what do we need to look at to decide if someone owes a duty to a plaintiff? And I feel like there's maybe a little bit of overlap here that you have to look at. So on the one hand, I'm not really, I got to say, like, I'm convinced that I could state a claim for breach of fiduciary duty against a software developer. I'm equally convinced that in 99% of the cases, I'd lose. And my thinking is, and of course I'm not an English lawyer, my hope would be that that's what happens here. It goes back to, what did you call it, the first instance court? It goes back to the trial court, and they say, some discovery is undertaken. I realize in different quantity than you have in the United States, but at the end they say, yeah, it's theoretically possible that there could be such a duty, but you didn't establish it here.
Right.
Steve, I think you're saying, like, move along, nothing new here.
No, not exactly. I mean, it's an interesting question, and I think it points to we've only had computers really since for
50 years, 60, maybe more.
When what you consider the beginning of computing, we've only had the World Wide Web for maybe 30 years or so, right? So the law will continue to develop. Take cars, for example. We haven't really thought through who would be responsible in a car crash case where you've got software that's involved in it. That's an area of law that's developing. So far, it's fairly ad hoc common law, and that's the same thing with software. But we can certainly imagine, I don't think that this case is one, but we can certainly imagine software systems where it would make sense to impose some sort of culpability, responsibility on the creators. I just don't think with open source software development, the proposed the cause of action or the proposed remedy makes sense.
Yeah, I have to jump in and say, I when I read this opinion, I thought it was extraordinary. I thought, for the court to say, we recognize that the state of the law is not here, but maybe, and they actually said, if we were to impose these fiduciary duties, they say this would be a giant leap. They say that this would not be an incremental change. This would be a major change. And yet they were saying, but if the facts are as they are presented, then maybe we should make this giant leap. And in my mind, it was almost as if the court was saying, you've got this decentralized technology. This is a big deal. Like, this is a big deal, and this could change things in the world. And if we're going to be making these big changes on the tech side, maybe we should be advancing the law. It's sort of like we here in the States, we often talk about our lawyers, like the law. And I think this is you, Stephen. I think I read a tweet where you're like, it's going to be a while for the law to catch up with all this tech. In my mind, you have these very thoughtful judges going, this could be the chance, like under the right set of facts. And I think that's probably why they kicked it back, right, Laura? Because they want to see, well, what are the facts? But under the right set of facts, we may be willing to change fiduciary law that's been grounded in precedent for hundreds of years and impose an affirmative fiduciary duty, which generally has never been done before. Like, to me, that's mind-boggling. Of course, I'm a Delaware lawyer and I work in the Court of Chancery.
I don't think that's what the opinion says, though.
I don't know. Maybe
I'm not sure I read quite so much.
maybe I read
into
more
it. I mean, I
into
think
it. Maybe I just read a little
yeah.
bit more.
The case
But
does, I think,
yeah. But I think it's an interesting question, actually, how does the law rather than the regulation of crypto develop? So the UK Law Commission has been looking at that both from a property law perspective, but also around like DeFi. And I think there's a debate, do we let the courts do their thing and kind of incrementally sort of develop things, or maybe occasionally take a big leap? Or do we look to actually put statute in place and kind of say, go through the legislative process and say, this is what we think should be the case with sort of consultation and so on. And I think, they're two opposing potential routes that we could take. I don't know which one we're going to go down yet.
Andrea, just a reminder to you as a Delaware lawyer, of course, right, that as a kind of background law matter, I mean, Delaware allows a lot of flexibility, for example, for an LLC to allow a full waiver of
fiduciary obligation.
I think it's quite a slippery slope if we're going to start to impose fiduciary duties on software developers. And that, by the way, goes beyond the blockchain arena, right? Think about everything happening with AI. The next thing you know, someone relies on ChatGPT to make a decision about where to go to lunch, and they get food poisoning. I mean, it's just the fact patterns write themselves.
Well, but let's take a slightly different situation where you've got someone who designs software for a vehicle, and the software causes a vehicle to, break arbitrarily, and as a consequence, someone dies. There's an established body of law and products liability law and negligence law that would probably assign some responsibility or liability to the developer. But it's different. What you're talking about there is a less attenuated relationship and more, I'm going to say, foreseeability, even though foreseeability is not part of the test as to whether or not someone is a fiduciary. But I think that's the way I come at it. Is it's going to be, I don't see this as necessarily creating a new body of common law. I think what we'll do for a while is apply existing common law strictures. It will happen eventually. I'm sure that we'll have codification, registration, and licensing of certain types of software development, much as people may hate that idea. But I think that may end up solving part of the problem. You'll be able to hold people who are licensed responsible for certain things, but people who are unlicensed won't be able to do certain things, but won't have culpability.
Yeah, that's a great point, Stephen. I just want to add that I was adding for dramatic effect some of the comments that but I do think it would be an extraordinary extension of fiduciary duty law and a big change if the court were to find that the BTC developers were fiduciaries. I'd like to turn the conversation now, I think, to our final topic, and it addresses the notion that some of our lawmakers are passing pretty, it's sort of they're passing laws and imposing certain types of obligations, or not passing, but they're considering laws that would impose obligations on folks that perhaps cannot be done, would be impossible. And in that regard, I would like perhaps, David, you could introduce the topic of the Illinois bill, that would require node operators, miners, validators to actually reverse blockchain transactions. And maybe you could talk about that, like and if they fail to do so, there's a large fee imposed, like a daily fee, but maybe you could just sort of, what do you think's going on here?
Yeah, so real quick, and I'm not trying to throw undue shade at Illinois, because I think the lawmakers there, are trying to protect consumers, which is not a bad thing. But there's this proposed item of legislation, which, if passed, would require a blockchain network to reverse transactions upon an order of a state official like the AG, irrespective of whether or not there's access to a private key. And that's just not how blockchains work, right? And it would apply to any transaction that originated in Illinois, setting aside the question of like, how do you identify from whence a blockchain transaction originated? It's sort of like passing a law that, water shall henceforth run uphill or something like that. It goes against the nature of how blockchains work. And I think what it's a little bit of a symptom of is there may be a little bit of a lack of technical understanding of this industry that we're seeing among regulators and legislators and in sort of all arenas. And I'm not trying to overgeneralize, because I think there are a lot of regulators and legislators who understand crypto very, very well and very, very deeply and very thoughtful. Gary Gensler, among others, is someone who really understands the technology. I think there's no doubt about that, right? But there's this issue where I think there are kind of like these ham-fisted approaches where people are lumping all things crypto together. You might not be able to differentiate between what happened with FTX and like, to use an extreme example, permissioned blockchain used for supply chain provenance or something. All of those things at some level are blockchain, but they're like as different as night and day. And I think it's important that before there are going to be policy responses, for people really to be thoughtful and understand what they're doing and understanding the knock-on effects of painting with too broad a brush. And with that, I'll turn it over to my colleagues here.
Did anyone else have any comments on the Illinois statute?
I'll just say that I think that there's a lot of, the education component is one thing. Like there's, the one congressman who said that we need to like hold our horses and pause the blockchains here. But like, that's one thing to deal with. What's scarier is when, you get a bill like Senator Warren's, which builds on the fight from the infrastructure bill on imposing KYC requirements and making like infrastructure providers and blockchain MSBs that basically outlaws permissionless tech. So, I think it's a double-edged sword. I think David made the point, like, you have to worry about regulators and policymakers that don't understand, but like someone like Gensler that does can be dangerous for different reasons, right? People are coming at it from different angles of sort of attack. And I think the more knowledgeable and intentioned attacks are the scariest.
Yeah, we're T-2. We're almost at the end of our discussion. I just want to give everyone in the panel, if anyone has any parting thoughts, words that they'd like to share.
Well, I just, first, I just want to thank GBBC for bringing us all together. And it's great to join a discussion on these topics with some of the best legal minds in the space here. So kudos to GBBC for advancing the quality of this discussion.
Thanks so much, Eric. I want to thank everybody here for this discussion. I know we also had some questions that we couldn't get to. And if you send me an email or send me a message on LinkedIn, I will try to get your questions answered. I will come back to if I can't answer it, I will ask my esteemed friends here on the panel to help me. So please feel free to reach out to me directly if you didn't get your question answered. There were a couple of cases we didn't get a chance to talk about today. There's a hotshot opinion. The court there refused to grant the motion to dismiss. That's definitely worth looking at, the Dapper Labs case. And there was also, I think, a filing in there was another case, which I'm just now beyond me. But anyway, I just want to thank everybody for being here. I want to thank GBBC. I want to thank Riley for helping us here today and helping us get through this beautiful discussion. And I think with that, we say goodbye. Thank you so much.
Thanks, Andrea.
Great to see you all.
Bye-bye.